Guardianship in hospital settings. There are a few key distinctions between guardianship and power of attorney. Guardianships are created by the court, but power of attorneys are created by the individual, and it is them extending their decision-making right to another individual. Unless someone under power of attorney is viewed as incompetent by a doctor, they may sign and make decision treatments themselves, in addition to the person who holds power of attorney. Either individual could sign consent forms and make treatment decisions. Under guardianship, the courts have reviewed the individual's case, looked at eligible family members and or people in the community, and designated an individual as their guardian to make all decisions on their behalf instead of them. A patient under guardianship may not make treatment decisions or sign consent forms. That's done in conjunction with the guardianship's oversight. It's important to reiterate that your patients under guardianship, unlike patients under power of attorney, may not, regardless of how they present at the time, regardless of the doctor evaluation of their mental status in that moment, they may not sign consent forms or make treatment decisions. The courts have looked at their long-term history and often psychological evaluations in order to make the determination that they needed a guardian. Guardianship patients should never be discharged without the guardian notification, so that way the guardian can assist them in that process. They may be unable to give much information. They may not even be aware they're under a guardianship at that time due to cognitive impairments. And if there's missing information, the guardian would be the one that would be able to provide this. The primary role of a guardian is to advocate for the client. They make all the decisions for the client, on behalf of the client, based on what the client wants, if the client's able to communicate that. If not, what the client has, what their history of decision-making has been, what the doctors recommend, what the treatment options available can offer the individual, and if they're not a family member, what the family member preferences would be. Their responsibility, though, is to make the decision they believe the client would make if they were able to understand and make the decision themselves, unless it's detrimental for them. They are also responsible, the guardian is responsible to report to the court on all decisions made and the care provided. And it's really important for the guardian to be able to work with medical staff and understand what is being done for the client, so they can make this and keep the courts informed on the individual's well-being and care given. There are multiple kinds of guardianship or levels. Full guardianship would be plenary guardianship, and that would be an individual who has decision-making rights for both the person's health, all of their personal decisions, as well as their financial. Or it can be over just the person and their health, or just over their estate and the financial aspects. And another important point is that the guardian is acting in place of the person. They're acting as the person. Their decisions trump that of family. As all in a healthy situation, the guardianship will take the family members' points of view into consideration, but the courts have decided that the guardian was the best fit to make decisions on this person's best interest. And the court, if they did not select a family member, there's probably good reasons why they thought this guardian would be a better decision-making agent. One last comment here. If an individual has only a guardian over a estate or a conservator, they are not able to sign for medical or personal reasons. They only handle financial. Guardians want good collaboration with the individuals who are providing care for their clients. One way that staff can help is to ask for the court documents, which would always be done, but once they're received, to upload them into the patient's file and ensure that they stay with the patient's records, so that any future medical staff who encounter this patient automatically know that they're under guardianship and how and who to contact. Then ensure that care providers know that the patient has a guardian and how they can be contacted, and that they should be contacted every time a consent or treatment decision is needed to be made. Then they can educate others on guardianship and the ramifications of serving a patient under a guardianship. If you're unsure if a patient has a guardian, you can visit the Indiana Guardianship Registry. If you're in another state, there may be an equivalent tool that you can access. I want to show you the Guardianship Registry interface. It's very user-friendly. You can just search for them by name, and you can narrow it down by birth year and hit search. It'll come back with a box like this, or a box that says no search found. And it can tell you the county it was issued in, the individual or organization that holds the guardianship. It'll tell you whether the individual or the estate is under the guardianship, and the issue date. The expiration date will only be filled in if it's a temporary guardianship. If it is a temporary guardianship, it is exactly the same as a regular guardianship, but will be expired or rolled into a permanent one. Thank you for your time, and please reach out to your local guardianship agencies. They would love to collaborate with you and find the best way to serve these clients. And being proactive can help prevent any red tape getting in the way of the clients getting the best care possible. Thank you very much.